Welcome to the Scaringi Law Lunch Break. This is that time of day to learn a little bit about the law while you enjoy your lunch. The Pennsylvania Supreme Court recently issued a very important decision for gun owners and concealed carry licensees throughout Pennsylvania. The court actually did away with a prior court-created rule that permitted law enforcement officers to stop and detain individuals merely because they were carrying a firearm. The case is called Commonwealth v. Hicks, and it was decided May 31st of 2019. Now, as you know, the Fourth Amendment of the United States Constitution requires law enforcement officers to have probable cause that a person has committed a crime before officers are permitted to conduct a search and seizure of that person. However, the famous United States Supreme Court case of Terry v. Ohio in 1968 allowed for an exception to this warrant requirement set forth in the Fourth Amendment in the following set of circumstances. And this is called the Terry Rule, or the investigative detention, or the stop and frisk. First, the investigatory stop must be lawful under the Terry Rule. That requirement is met in an on-the-street encounter when the police officer reasonably suspects that the person who is apprehended by the law enforcement officer is committing or has committed a criminal offense. Second, to proceed from a stop to a frisk, the police officer must reasonably suspect that the person stopped is armed and dangerous. However, the Terry Rule is still the law of the land, by the way. In Pennsylvania, courts developed a different rule called the Robinson Rule in cases involving when a law enforcement officer comes upon a person who is carrying a concealed firearm. Under the Robinson Rule, the possession of a concealed firearm by that individual in public is sufficient to create a reasonable suspicion that the individual may be dangerous, such that an officer can approach the individual and briefly detain him in order to investigate whether he is properly licensed. So that's the Robinson Rule. It's been the rule in Pennsylvania since 1991. However, just a few weeks ago, the Pennsylvania Supreme Court in Commonwealth v. Hicks declared the Robinson Rule contravenes the requirements of Terry v. Ohio that we just discussed, and as a result, the Robinson Rule violates the Fourth Amendment to the United States Constitution. Now, let me give you some of the facts of the Hicks case so that you can see how these rules come into play in a real-life scenario. Mr. Hicks entered a convenience store early in the morning. Videotape shows him taking his firearm out from his waistband, showing it to a patron of the store, and then leaving the store and getting back in his vehicle that was parked in the parking lot. The police were immediately notified. The police arrived right away and intercepted Mr. Hicks before he could exit the parking lot. Police officers surrounded Mr. Hicks' vehicle. One reached in to his vehicle and restrained Mr. Hicks, while another officer reached in and pulled the firearm out of Mr. Hicks' waistband. Mr. Hicks was then removed from the vehicle for safety reasons and handcuffed. The officer, at that time, smelled alcohol on his breath and thus searched him and found a small bag of marijuana. Now, upon further investigation, it was determined that Mr. Hicks had a valid license to carry a concealed firearm. Now, he was later charged with DUI, possession of marijuana, and disorderly conduct. But the police officers justified their detention of Mr. Hicks on the grounds that he had a concealed firearm. Under the Robinson Rule, the court said that's sufficient to create reasonable suspicion that Mr. Hicks was dangerous, and thus the officers were permitted to detain and seize and search him. Now, that was the Robinson rule, and that's what the police officers were following. However, Mr. Hicks got an attorney, and he filed a writ of habeas corpus challenging the disorderly conduct charge, and the trial court granted the writ and dismissed the disorderly conduct charge. Simply removing your firearm from your waistband to show it to a friend in a public place does not rise to the level of disorderly conduct, according to the courts in this case. Now, Hicks' attorney also filed a suppression motion requesting the evidence of the smell of alcohol and the firearm be suppressed, meaning kept out of court, on the grounds the search and seizure violated the Fourth Amendment. The trial court denied the Hicks motion to suppress, and the Superior Court agreed with the trial court and applied the Robinson rule. The trial court and the Superior Court concluded that under the Robinson rule, it was lawful for the police officers to seize Hicks immediately upon learning that he possessed a concealed firearm in public. However, the Pennsylvania Supreme Court reversed the Superior Court and the trial court and, more importantly, abolished the Robinson rule in Pennsylvania and declared that law enforcement officers are not permitted to detain and question a person solely on the grounds that the person is carrying a concealed firearm. Now, this is a big victory for the Constitution, the Fourth Amendment, gun owners, and concealed carry permit holders across Pennsylvania. Now, the Terry v. Ohio rule, the Terry rule, is still in place. A police officer can stop and frisk an individual if the officer has reasonable suspicion that that person has committed a crime or was involved in the commission of a crime and is also armed and dangerous. That is still the law in Pennsylvania. But the Supreme Court in Commonwealth v. Hicks abolished the Robinson rule that allowed law enforcement officers across Pennsylvania to seize and detain an individual solely on the grounds that he was in possession of a concealed firearm. Well, if you have any questions about the Fourth Amendment or firearms law, don't hesitate to contact the attorneys at Scaringi Law at 717-657-7770. That's about all the time we have today for the Scaringi Law lunch break. I hope you learned a little bit about the law. Thanks for listening and enjoy your lunch.